everything that happens in the courtroom uh, requires a lot of preparation. Every hour in the courtroom takes a week of preparation. And I think that really holds true, especially with demonstrative evidence. My number one foundational goal as a lawyer is to understand the rules of civil procedure, to be able to maximize my workup on a case, and also the rules of evidence, so I know exactly what is going to be admissible at the time of trial. I think the most important part of this is clarity beats cool. You always want to do the legwork to make the demonstratives or the demonstrations as simple as possible, while also not losing anything.
Welcome and thank you all for joining us for another Justia webinar. My name is Nina and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speakers for today, Eric Ganci and Noah Moss. Eric Ganci is a seasoned trial attorney with the Ortega firm who has dedicated his career to representing people whose lives have been disrupted by serious injury, injustice, or wrongdoing. Known for his courtroom experience, strategic insight, and relentless advocacy, Eric has tried more than 70 cases to verdict. He began his legal career as the founder of his own practice, where he quickly established himself as a formidable trial lawyer. Over the years, he has represented clients in complex and high-stakes matters, ultimately recovering millions of dollars in verdicts and settlements on their behalf. Noah Moss is the founder of Shepherd Law, a national trial firm dedicated to representing families and individuals in catastrophic injury, wrongful death, and civil rights cases. Noah's work as a civil lawyer over the last 14 years has earned him the Consumers Attorneys of San Diego's quote-unquote Game Changer Award, the Daily Journal Top 40 Under 40, and Super Lawyers Rising Stars honors. He also presents nationally, including at the AAJ Annual Conference alongside his fellow TLC graduate, Eric Ganci. The webinar presentation that you're about to watch will be approximately 1 hour, and if you have any questions, Eric and Noah will be taking those at the end of the presentation, but you can submit those by clicking the Q&A button in your Zoom control panel and sending them in there. Now, without further ado, here are Eric and Noah to discuss priming and demonstrative evidence.
Hey, everybody. Hey, Eric.
Everybody. Hey, Noah. What an intro, huh?
Let me bring the slideshow up here. That was quite the intro.
It feels like the start of a game show. And now, let's bring out Noah and Eric.
I know, right? I guess I'll jump into it here. We want to start by sharing our contact information. This is a narrow window today to talk about a pretty big topic, especially in this day and age where we have the age of social media and quick bites and everything is visual. And so we're here to talk about the big topic of bringing that into the courtroom. And we know, Eric, from grueling experience, that everything that happens in the courtroom requires a lot of preparation. In some cases, years worth of preparation. I think Eric and I are both graduates of the Trial Lawyers College, and back in the day, it was run by Jerry Spence, and Jerry's one of his pearls of wisdom was that every hour in the courtroom takes a week of preparation. And I think that really holds true, especially with demonstrative evidence, because these days, at least in our world, where we represent personal injury plaintiffs and individuals against government, corporations, but I guess in any area of practice, people are starting to really understand the power of visual storytelling in the courtroom. And they have for a long time, but it's becoming a lot more acutely important because of how, frankly, short our attention spans are and how little interest people have in reading lawyerly slides with all kinds of words on it. So we're going to do our best to keep that to a minimum today. We're going to do our best to keep this fun and entertaining, but also dig in and try to give a presentation with some teeth and some stuff that folks can take back and just act on right away. So that's our contact information. Both of our cell phones are up there. Use it, don't abuse it. And let's get started. So I'm going to take this first slide here. I read a book not so long ago called Atomic Habits. And that book was a lot about brain science and neuroscience as a setup to how we form and also break habits. I wish I put the citation up here, but the big takeaway that I had from that book was there was a whole chapter about the number of neural connections in our brain, and uh, the overwhelming percentage of them, about 80% of the neural connections in our brain that are dedicated to sensory perception and processing are visual. And I thought about that, and it just blew me away. It was something that I think maybe I knew intuitively, but when I read that, it was one of those kind of watershed moments in it for me where I started to understand law practice differently. I realized that all the papers, the pleading papers, and the legal pads, and the things that we use to communicate about our cases, it's really two-dimensional when our world is a three-dimensional world, and we process so much more of the world visually as human beings than with just about any sense. And we're going to talk about how to combine some of the other senses that are really impactful, namely sound and smell, into our work with demonstrative evidence. But that's really where I want to start, and it was a foundational thing for me, at least, when I started to think about how to work that into depositions and briefs and communications with opposing counsel on my cases, communications with judges, um, mediations where I want the mediator to be able to see who the witnesses are, as opposed to just reading about what they're saying, or heaven forbid, listening listening to me summarize their testimony or what their testimony is going to be. So for jurors, and also, this goes for courtroom work, negotiations, mediations, contract negotiations, all kinds of work in our practice. We have to understand that our audiences, they process the world visually, and to me that helps me prioritize visuals and search for visuals while I'm working a case up. um and it and and this starts to get into more of a personal creed of mine, I think, when it comes to courtroom work. And I know that this is something Eric and I talk about a lot, is when we're trying a case, the challenge is to step aside as the lawyer and allow the case to come to life for the jurors. And again, understanding that jurors, they are human beings just like the lawyers, and they process the world visually. So the challenge for us when we take cases to trial with the medicine, with the legal arguments, with the witnesses, is to help jurors tap into that visual component, and during the case workup, start to understand where you can really mine the discovery and the witness testimony, to be able to connect with that mind's eye in the jurors. Because if the case comes to life for them, that's a very persuasive place to be. So this kind of reinforces the percentage of the neural connections in our mind and in our brains that are dedicated to visual processing. I put an article in there that sort of reinforces this, and feel free to check it out. It's a fascinating article, and I think this is going to dovetail into kind of the next piece of this presentation. Um, there are a number of different types of way to bring visuals into the courtroom. Of course, there's photographs. Of course, there are now animations, right? There's a lot of work you can do, and I just tried it this morning. I'm not ashamed to say that I plugged in some of a description of my client's injuries into a paid version of an AI program, and was able to build a visual model of the surgery that my client went through. Um, in this day and age, demonstrating that kind of thing is way more powerful than talking about it. And I know where Eric is going to go here at some point, and and this is another really important way to tap into jurors' minds, their mind's eye, is demonstrations in the courtroom or reenactments using witness testimony. This is something that we study very closely at Trial Lawyers College, and is something that Eric actually is on staff and has been on staff at the Trial Lawyers College for a long time. So not only does he practice this, but he teaches it to lawyers all over the country. So we'll get into that a little bit, but yeah. So these are the tools that are available for bringing visuals into the courtroom. And another thing that we always get pushback on at Trial Lawyers College, and also we have to think about along the way as lawyers, right? It's one thing to let your mind go creatively, but at the end of the day, we're constrained in some ways by the rules of evidence and the rules of procedure. So my number one foundational goal as a lawyer is to understand the rules of civil procedure, to be able to maximize my workup on a case, and also the rules of evidence, so I know exactly what is going to be admissible at the time of trial. And I like to think of the rules of evidence and the rules of civil procedure, or if you're in a criminal law practice, the rules of criminal procedure, also the rules of evidence, or if you're in, say, for example, a military tribunal, they've got their own UCMJ rules of evidence and procedure. I like to think of it in terms of, for example, poetry or genres in movie making. We have these rules that everybody plays by that are tried and true, but within those rules you have unlimited creativity and an unlimited ability to go out and be creative, so long as you're using those rules as a foundation. So I like to think of those as something that I study almost religiously, to make sure that I am constantly up to date on what I can and can't do, so that when I get into the courtroom, I've got a lot of leeway to bring visuals into the courtroom, and also a lot of leeway during discovery and in depositions to overcome objections when I'm trying to do something a little outside the box. So speaking of the workup, I will kick it to Eric here, and he's got the next slide, and he's going to talk about some visuals and bringing visuals into your discovery. So take it away, Eric.
Yeah, thanks, Noah. Thanks for teeing all this stuff up. It makes me think of, and I can't remember, Noah, if you and I have talked about this, because we've just talked about, like, we just geek so hard on all this trial practice stuff. But, as a musician, you can see the drum set in my back. I can hit my cymbals. But, I used to always, when I was a band director and performing and teaching people how to perform, I would always say that audiences hear with their eyeballs. And what that means is, a lot of times the audience may not know, in the musical sense, the audience may not know whether or not you're a good performer or a bad performer, because they may not have that training and education. But what audiences do know is how you react to something. So if it looks like you're having a lot of fun on stage, oh my God, Noah must be the best guitarist ever because he's just having a ton of fun up there. Or if Eric's playing drums, and this is what I used to do, I would play drums and I would mess up and like really beef something up. And I'd be like, oh, you could see it in my face. And then my family afterwards, or my friends, would be like, you look like you're having a hard time up there. And I was like, I need to stop doing that. And so then it turned into, when I started making mistakes, I would just enjoy the mistakes. It's just a learning opportunity, right? And then afterwards, people are like, you're so fun to watch. You're so good. I'm like, okay, it's total, some of it was trickery. But that's a lot of what we're doing with our jurors. Like, they learn, they see with their eyeballs, they hear with their eyeballs. And that includes how you're acting on, how your witness is acting on stand, and how you're acting in the courtroom. But in particular on how do we show demonstratively with scene setting. And that's something that we'll talk a little bit more using Trial Lawyers College techniques. We'll give you just a seed to plant with that. And then, of course, we'll invite you to go to Trial Lawyers College, their website, and then check out some upcoming trainings that we got going on. And Noah is deep into that training as well. So it's wonderful. But Noah and I used this scene that was an auto versus pedestrian case that we worked on. And at first glance, you may be thinking to yourself demonstratively, like, oh my God, this looks like vomit on a page, because looks like Eric can't draw letters on a on a diagram. Partially true. But once we get through expressing what this means, it'll make so much more sense. So what happened here in this case is that delivery driver, not paying attention, is driving south on this road. Our dude is walking across the street in the crosswalk, and then ultimately he gets, he's going through the crosswalk, and then blammo, this delivery truck like just nails him. Super sad case. But when we're putting together the discovery, what actually happened, if we were to like talk through it, as many attorneys would, and how I used to do, it would be, for our form interrogatories within California and maybe other states, give an explanation as to what happened. All right, well, if we're to talk it through and put words on a page, it's plaintiff exited his vehicle, walked 30 yards north, then turned eastbound and walked into the crosswalk area while defendant driver was proceeding south through the stop sign. Is like, oh my goodness, like if I hear those words, like I'm lost. But if we can present to the audience, and the audience can be the jury, can be the judge, and for purposes of doing like discovery responses, the audience can be the person who's reading your responses, and also your client who's reading the responses to make sure that everything is accurate. What we did here was, at marking B is where plaintiff parked his car. At marking C is where he gets out of his car and starts to walk. At marking H is where the defendant driver was. And I may be getting some of these letters exactly wrong or partially wrong, and we'll show on the next slide exactly how we expressed it. But then we're just showing a picture as to, like, at marking D is where plaintiff intended to go. That's where he's walking. And also at marking D is where we had a friend that was an independent witness that was there watching the whole thing happen. At marking J is where the contact happens. And then at marking L and K is where there were barricades on both sides of the street. So then, if you can go to the next slide. So this is how we expressed it, and I won't read the entire thing, but you can say, at marking B, plaintiff parks his car, blah, blah, blah. Plaintiff walks to marking C, at marking C, and we're just expressing exactly what happened. Now, what we're also doing with this is locking in our client's story, so that if this case were to have gone to trial, then our client's going to then take the stand and be able to express it, and it's going to be much more consistent story of what happened, as opposed to him taking the stand and saying all of these numbers. I walked 30 yards north. I turned east I walked exactly 7 seconds, and then I turned east. And this is where attorneys can get really tricky, especially if you get like accident reconstructionists or biomechanical experts and that kind of stuff, human factors experts, that those experts can sometimes get into the nitty gritty and the numbers and start to play with it. So then if one of the parties is saying, I walked 30 yards north, when in actuality it was like 25 yards north, and maybe that's a huge part of the case. But then if we have that as evidence, maybe that would prove or disprove something within the case. Or if your client takes the stand and says, whether you're plaintiff or defense, and if your client says something that's wrong, well, they said 30 yards in their deposition, and they said 28 yards in their formal written discovery, but then at trial they said about 35 yards plus or minus 5 yards. Well, now there could be a credibility contest, but also that could be stuff that the experts can get into and play with. So being able to just like lock this in as a picture, it makes a lot more sense. And then we just, like, this is what we did in this case, is that we just responded to, in California, this form wrong 20.8, which is kind of like an explanation of like, hey, explain like what happened. Well, here you go. Boom. Or put this into your complaint, list this out, and then attach the picture to it. So then everyone can just understand, oh, okay, I understand exactly how everything happened within this case. Cool. Noah, anything to add to that before we go to the next slide? Cool. All right. So this.
No, I mean, you said something that I hadn't, I don't know if we've talked about it or not in reference to this, but you said something about really galvanizing your client's story against cross-examination. And I think that's such a huge takeaway. And so thanks for sharing that. I wrote that down as a note of, picture's worth 1,000 words, and a story in trial is very difficult to cross-examine. And plus, you know, walking your client off down the plank of having to know the exact measurements. Nobody talks like that. Only in court do we occasionally exit a vehicle, walk northbound 10.5 yards and turn southbound, you know? So, gosh, that's a really, I'm going to take that with me today. So thanks, Eric. That was something.
Yeah.
The flag.
Yeah, for sure. Well, and it's also like use this stuff in your depositions too, that if you're either cross-examining somebody, putting this together, and depending on how your case is and what you want to express, maybe you do want to use numbers, and maybe that's what you're turning into a demonstrative. Or if like Noah, what you've said, that's what I was thinking of when you started talking about it. Your statement of it's hard to cross-examine a story. It's easier to cross-examine data.
Right.
But yeah, you've said that for years. It's hard to cross-examine a story. So then if your client is getting grilled at depo about numbers and data points and yards and distances and times, you know, maybe the true story is, look, I don't know exactly what it was, but this is what I do know. Here's the picture. And then always just have them come back to that. That can be a very powerful way to express what it is. So, okay. And then this is just a side-by-side to show. And I'll also say demonstratively, like when you're in depos, like use Zoom. So like if you're like a little afraid of Zoom, our invitation to you is start to get crazy with this stuff. Like when you're in depos, put stuff up and then start to like draw on it, use arrows, use like letters and stuff like that, so that you can mark up exhibits. And, you know, having just done so many trials, I just have seen so many, unfortunately, bad examinations. And, you know, I was probably a part of them for like my first 15 or 20 trials where I'm trying to explain and trying to make a record of something. Like just start to mark some stuff up and then just say at A, where I've marked A, is this where XYZ happened? And I'll encourage you to use numbers and letters as opposed to like circles. Because what happens is, you know, the attorney will say, where I've circled on this diagram, is this where whatever happened? Well, what happens if you end up circling a bunch of other stuff? Like you want to make your record super clear, especially in case the case goes up on appeal, but make it super clear. At A is where X happened. At B is where someone was looking. At C is bang, bang, bang. But get used to this, and at depositions at Zoom or live, start to rock this stuff out, mark it up, and then Zoom, at least right now, is at the time of this recording on March 5th, 2026, Zoom lets you save a marked up exhibit, save that, it's annotated, and then mark it as an exhibit within your depo, and then boom, now you have something that's super, super clear. Then you can give that to the experts and, you know, see where everything sits with that. Okay, let me take out the annotations. Zoom's moving a little bit slow today. Cool. Okay, so I think that we're good for the next slide. Also, I couldn't help but peep the participant list, so I'm giving a shout out to Katie McBain, Cat McBain, who runs her firm, Cat Esquire, Cat Law. So good to see you here, Katie, and a bunch of other friends as well. Okay, there is, if you use this QR code, that'll take you to a video that we put together about diagramming a scene that we made back in 2025. So that can be a way for you to train your team if you want to use this stuff, or your investigator, about how to do this. So it's kind of like this in a box. And to the next slide. So this was something that investigator extraordinaire, his name is Jay Paulino. He runs his own investigation company, and Noah and I and Katie have worked with him a ton. Shout out to Jay Paulino. His last name is Paulino. He just has all this wonderful experience in doing drones, drone photography, drone videography, and certifications behind that. But it's so important to be able to map out like the path of travel. And let me see. For similar ways to be able to, like this case that we were talking about right here. It was a case where our person was, you know, stopped at the stop sign, and then she starts to make a left turn, and then defendant driver comes down, and then blammo, like nails everybody in the car. Unfortunately, someone died as a result of this. But being able to zoom out, and of course you can do this through like Google Maps, and then Google Maps will let you pick certain dates and time, and then you can move to subpoena those documents to get like a lock-in as to what a roadway looked like. Or you can drop like the little Google person, bloop, and then you can like look around to see what obstructions, what lines of sight there may be, what markings on the roads there may be, and then you can seek to subpoena that stuff from Google. But this stuff can be so important. Also, like Jay did a great job with this case where he just stuck a video device, like a recording device, on his car just to show the path of travel, and that can be really important. Lines of sight, you can have your experts do that. You can have your clients do that. That can be a great way to express what happened. Okay, and then with that, we can go to the next slide. This was something that Kelly Breckenridge, also another fantastic investigator that Noah, Katie, and I have had a pleasure of working alongside. She came up with this, and as soon as she did it, I was like, oh, snap, this is like awesome. So this was an auto versus pedestrian thing that happened in this box that I'm marking as an X. So the issue in this case was this light that's within that box. What was the color of the light as the defendant driver was coming up before he blew into a bunch of people? And so she has, as you can see, this first arrow is green, this next arrow is yellow, and then this last arrow is red. And that shows like the sequencing of the lights as this defendant driver was clearly like racing the red on that to blow into a bunch of people. And then these other markings, A, B, C, D, and E, is like where other people were crossing the street. And then when they first saw the vehicle, the car, and then where E is where the person ended up after this dude like ran into the person. So I thought that was a really brilliant way to set this stuff up and get creative with this. And there's lots of companies that can help you put together demonstratives. And Noah mentioned using like AI programs too. Like, I don't know that you'd want to use that in trial. Maybe you would, because I've had some AI programs like really create some really nice demonstratives, but it can just get your juices flowing, and then you can present something at a focus group so that you're doing something either on the cheap or the free, to then understand, okay, this is what I'm understanding, and then present it to a focus group, and then start to A/B test some things. The jurors like this, they didn't like this. And that way you can see like how your demonstratives are coming together. Noah, thoughts on that before I go to the next slide?
Yeah, I think this is I just want to flag, this is very much what I like to think about as an orientation visual. Confusion and disorientation are the enemies of the trial lawyer in the courtroom when it comes to communicating with jurors, and also judges and mediators and any audience really. This is like scene setting where you're using a visual map to orient the people into the scene that you want them to be at so that they can understand. This is a difficult thing to overcome in our trials, but it is a very easy tool to get people really oriented to what it is that you're trying to do. And I think the next chapter of this presentation is going to really help us understand, okay, now that we've set the scene and we brought people to the location, what is going on internally with those people at the scene, the characters in the story. So this is a good place to mark that, because we've talked a lot about visuals, speeds, timing, really all of that. The way I think about it is just to get people oriented to the locations, but we also have to explain and get folks to understand what's happening with the people involved and their decision making, and not just what happened, but why. Why is it that this person did the unthinkable in this case and blew a light and ran into a person in the middle? I mean, 1, 2, 3 lanes into the crosswalk. Why on earth did that happen? So we're going to jump into that in the next chapter of this presentation. So
yeah, great thought. It also shows the other side, like, hey, you're taking this case seriously. Like, you're putting a little bit more effort into just putting words on a page, which goes a long way, and it's, I mean, this is a topic for another discussion, but like, we just see so many lawyers prepare for mediation, but like, if you're preparing for trial and always preparing for trial, and showing the other side that you're always preparing for trial, then people just take you more seriously, and then your clients get better represented that way. So, but that's a bit of a soapbox, and that's a different topic to go on. Okay, so we'll jump into the next slide. No, I think that I'm still presenting on this, right?
Yeah.
Okay, cool. Yeah, I got a handful of slides, I think, after this one. So going back to the TLC, Trial Lawyers College method, and using psychodramatic tools, we're going to keep using this example of the auto versus pedestrian, where this delivery van runs over our guy in a crosswalk. And had that case gone to trial, we settled it, and did well by the client. But our plan was to get our client off the stand to be able to like set up this scene in the courtroom so that the jurors can really understand one and really be able to feel what happened. So like, Noah, your point about you set the scene, you lock that in, and then you can really express what's happening. Like what a brilliant way to express that. So something that we would have done with this, and this is very much a TLC psychodramatic method of doing this, is have our client get down off the stand and then walk the scene and put him at, and maybe having the demonstrative of the picture of with all the letters so that the jurors are understanding that this is like the intersection, what it looks like, and then have that client like mark off like where that was. God, I don't want to use his real name, so we'll just call him, we'll call him Eric. No, let's use a different name. Let's call him Adam. So Adam, stand where it is that you were parked your car and that you first get out of your car. And then we mark that, okay, solidify that. Okay, now get out of your car. Gets out of the car, walk to where it is that you're walking. Okay, now walk to where it is that you go into the crosswalk. And so then he's marking that stuff off and setting up, and so then jurors are seeing this. They see the picture up there, they see him walking. And so now they're starting to see like exactly what it is. And then as he's doing that, what are you smelling? What are you seeing? Like, look up at the sky. What are you seeing? Well, that day it was a clear day. It was like middle of the morning, like San Diego, beautiful. So like not clouds in the sky. It's not like anything. It's not like it was raining. It was hard to see. Our client was bigger in stature, so like he was just very easy to see. How he walked was also a demonstrative that we would have definitely got into, because he walked so slow for reasons that I won't get into, but he had some health issues that for reasons that he was walking so slow. And, ultimately, as he's doing this and walking, the jurors would have been thinking, we think, like, how the heck did you miss this dude? Like walking so slow, and he's like 6'4" and he's like 300 something pounds. Like, how did you miss that? Well, I mean, there's an answer to that, is that the driver wasn't paying attention because he was like looking left while he was driving down the road, which was something else that when Noah and I deposed that driver, that we were using that as a demonstrative in the deposition. So we're showing like looking to the left so that we're setting that up. Anyway, so like that's a piece of like how it is that you get to showing this in the courtroom at trial or for motion or whatever. So, but how do you get the permission to do this? Because usually at this point, when we're doing this stuff at Trial Lawyers College, people say our judges, our courts, our opposing counsel would never let this happen. And maybe that's true. Maybe it's not true. I will say that, and no, I'm sure you feel the same way. I've done this a bunch in trial, even in jurisdictions where it's like, this would never be allowed to happen. As long as you're being honest with it and you're doing it with purpose. If you're just doing it to do it, then good luck. Then you're going to get smacked around. But ask the judge first, and then the magic words or phrases-ish to say to the client is, do you think that it would be helpful if you showed us what you did? Would that be helpful for the jurors to understand what you were doing? And of course, you have practiced with your client for this so that the answer is yes, as opposed to, I don't think so. And then you have the person come down and then showcase it. So then now we're setting the scene. It's solidified in the juror's mind. And many times the psychology of that, because we're hearing and learning with our eyeballs, is that once you set the scene, until you strike that scene, the jurors will remember that scene. And especially if you honor the scene, that if you're ever doing something, if you're walking around something, and if you're consistently like staging yourself and standing like where the contact happens, like all that stuff is so important. So then to get to Noah's point about once you're in the scene, now we can really express what happened. Sure, we could talk about liability, And that can be important for the scene. We probably would have done that. But also for a damages piece, like that's where we'll talk just briefly on how powerful this can be. Because what had happened is, I'll just walk you through it. So like, Adam, get yourself in there, and then you're walking. Okay, walk us through. We're staying in present tense. Note that, which is another topic that we can get into probably in a different presentation. Walk us through where you're going, staying in present tense. Okay, now where are you going? How are you feeling right now? Well, I feel fine. Like, there's not a lot of traffic going on. I'm going to go to do this thing that he was going to do. Okay. And then turn right for us. And then you're starting to cross the crosswalk. What are you doing? Well, I'm looking at the crosswalk because I know that I don't move very fast. And I know that I need to stay inside the crosswalk. That it's important to me. Well, where are you walking towards? Well, I'm going towards the curb because he had a problem walking because of his body makeup. And so he would always take the ramp and never the curb because the curb was too big of a step up. All demonstrative stuff. All right. Well, then if we're doing damages, because our guy sees the van right before it hits him. All right. So, Adam, I hate to do this to you. And you have to be careful with how you're doing this because this can really, really injure somebody. So take lots of precaution and maybe involve some sort of a therapist. We use a lot of psychodramatists, but someone that's a professional, because if you put someone in this place to work them as a damages witness, you run the risk of really hurting them. So be careful with this. But if we did this and we put Adam in the situation, Adam, now turn to your left, and what do you see? I see the van. Well, what's going through your mind as you see the van? And so now we're slowing things down. In theater, as Jesse Wilson says, and lots of other theater folks say, if things are going slow it down. All right, Brian, you're at the part. We know that you're going to get hit by this van. I hate to do this to you, but we need to talk about this because the jurors need to know what it is that you went through. Turn to your left. What do you see? I see a van. What's going through your mind? He expresses it. All right, what else do you see? Well, I can't move. I'm kind of frozen in fear. Why? He explains. And then you see the van coming towards you. Slow it down. Inch by inch. Maybe inches are too small. Second by second, maybe, who knows? But what we know is that our guy turns toward the van. He puts up his hand and he's yelling, stop, stop, stop. The delivery driver is looking to the left because he's trying to cut his route to go through something else that he didn't see, which is a route planning thing that Noah was brilliant in setting up within that deposition. And then Vango, like the driver, runs into our guy, and he sees this, our guy Adam sees this happen the entire time. So then we can do it frame by frame, and we can slow that down. And what a very powerful way to express what it is that he went through as he's flying through the air then, and then he hits the ground, and then goes to the hospital immediately thereafter. So I think that gives one taste of how it is that we can do this. It takes a lot of work, and it takes a lot of care and caution and love to be able to do that, but it can be, as hopefully you're feeling and seeing, a very powerful way to go through and do this. Know anything else that you want to add to that?
Yeah, because I think you talked about something really powerful, and also that we really need to be mindful of when we have, the phrase, with great power comes great responsibility. And if, for example, you're dealing with a scene that might re-traumatize your client to the point of causing harm, and the only way to know that is to engage professionals. Eric and I have represented kids and I know a lot of folks on here have represented kids in some pretty tough cases, particularly in situations like that. Use other witnesses, right? Have your client set the scene up until the point where it's no longer safe for them, and leave the scene in place and call the friend that's on the curb to come up and give a different perspective on the same scene. And in some ways, depending on how you sequence it, you've given the jurors the fear and anticipation that your client feels up until the point where it might be too much to have it reenacted through their perspective. And then you allow them the relief and the detachment, but also a different type of concern from seeing it from an eyewitness's perspective.
Yeah.
So being really mindful of, in these scenes, what perspective are you going to tell the story from is a very important choice. And if we're talking about the driver, for example, why is he looking left? What's so important to the left that he's not paying attention to what's right in front of him. Well, you dig into that and you find out that the company that he was running routes for that day, well, they didn't advise him that downtown San Diego, there was a marathon being run, so there was going to be road closures. So he encounters this situation where he doesn't know the route. He's on a time schedule. He's got 120 deliveries to make that day. Oh, okay. That's why he's looking left. He's encountered something that he wasn't expecting, and his company put him at a disadvantage by not doing any kind of route planning for that particular day. All right, so we've got the scene now from the friend's perspective, from our client's perspective, and also from the driver's perspective. Those are all creative choices that you have available to you when you get a scene set. And maybe it makes sense to show one of them, or maybe it makes sense to show all three at different stages of the trial. But these are really powerful tools that you have available to you.
Yeah, totally.
And the fun part about the next slide is, what happens when it all goes haywire? What happens when the judge shuts you down? Is that lost? No, because you've got Eric Ganci at the helm.
And Noah. One more point on that. A lot of, because Noah, that's such a great point that you just made. A lot of times the actual event happening is so damaging for the client to have to relive, and maybe that's not the part of the story that you want to tell. And I know within Trial Lawyers College, many times for very serious cases, especially if it's like a sexual assault, a lot of times we don't actually do the actual physical assault going on, for obvious reasons. And maybe the jurors aren't ready to see that too. Think demonstratively, like, this is why you want to focus group this stuff too, that, if you were to show this, is it overkill for what you're trying to do? But, I know in TLC, like, especially like, for example, if we're working on a sexual assault case, like we never actually do the assault. And many times it's not the assault that's the issue that you want to get to. You want to talk about what led up to before, or what someone did afterwards. Cause can be a lot of information. Anyway, so there's
Eric, if I can jump in on that real quick too, because and sorry, this is the geeks coming out of us. We're geeking out. When it comes to those types of like hyper traumatic moments or really heightened moments, it can almost be more impactful not to speak it or not to show it, and allow the jurors' mind's eye and imagination and hearts to feel it without having, as lawyers, we want to get every detail out there so that jurors understand, or the decision maker understands the case from every angle and in the level of detail that we understand it, feeling like, and I've been guilty of this, where it's like, I've got an obligation to a client who's very traumatized and has a lot hanging in the balance. Like, I need to overprove my case. And you can kind of run into trouble with that. But if there's a moment like that, let it, let jurors' imaginations fill in the blanks, and have faith that the scene that you set up has already done the work, and the visualization that you've really, and the feeling that you've set up with this really important work, let them take it to the house. And by the house, I mean the deliberation room. And so I wanted to mark that, because that's something that's we have a huge responsibility as trial lawyers, not and the responsibility is obviously to our clients, but it's also to jurors. And you can, I've been in situations where it's like, how do we pitch this?
Yeah.
How do we show this? Maybe we just shouldn't. It's unspeakable. We don't want to turn people off or alienate ourselves or our clients from it. So I just, sorry to jump in. I just wanted to mark that for us.
Yeah, it's such a good point. And that's why this art of trial lawyering is so beautiful. And so it's, we're talking today about demonstratives, but so much of all of this that we're talking about is the art of storytelling and the art of trial lawyering. And if you've done your demonstrative right, it educates the jurors, makes it simple, but then it also connects the jurors to something within their own life, so then they can then relate to it. and I couldn't agree with you more, Noah, that, we as lawyers, we've been living with the case for a few years, many times, and then you show up and you just got to talk about everything. And then it's just like too much information overload. And I know that Jesse Wilson talks about this in his books, and Noah, you and I have talked about this before, that many times leaving the trial story unfinished so that the jurors can finish it for you, that's where because you have to give them act hunger. And if you finish the story for them, then they have nothing left to do. And I think back to, some of the trials I did where jurors afterwards were like, man, we just wish that you would have said X, Y, Z. And why didn't you talk about this? Why didn't you talk about that? Because when we were deliberating, we were talking about boom, boom, boom. And that was a verdict that was, or these stories I'm thinking of were verdicts in my favor. And I'm thinking, I just got my mouth shut, just let them talk. But I'm like, I didn't have, it's smarter storytelling for you all to finish the story as opposed to me finishing the story. Had I finished the story for you, you just would have been like, have a cigarette. Okay, great story. Where can we give you a low verdict or defense verdict and get out of here, kind of a thing. So, oh man, there's so much art to talk about. All right, we got 15 minutes to move. I know we got 15 minutes left, right? So what happens if this gets objected to and sustained? Have a backup plan as if it's not going to work, and have some other demonstratives available. Use butcher paper and marker and co-create the scene. No, you talk about co-creating a scene with the jury so that they're seeing it come to life in real time. I don't know that we have a ton of time to get into that, but that's, just to have a backup, assume that the other side will object and assume that it's going to get sustained, and then you better tuck and roll with that. So, all right, I'll go to the next slide.
Yeah, it's easy. It's like, instead of having your client walk it through in the well, you just draw a picture while they're talking you through it. And what judge out there is going to prevent you from using butcher paper and a marker? I mean, that's the okay.
Yeah.
Next one. We've talked a lot about this. Eric, do you have anything to add for this slide?
I'll just simply add that if it's actually the back slide, the slide prior. If it gets subjected to and sustain it, then maybe you can just argue in closing argument. You can still set the scene, and it's still demonstrative, even if you're not presenting it as evidence. So, no, I don't have anything further to add with slide number 9. 3-step approach: set the scene, populate with people, let it run dialogue. I think we've dove pretty deep into that. We'll go to the next one.
Yeah, and I think, again, this is kind of the arc of this, is to really orient people to the scene so that when the people start to act and talk, the mind's eye can't help but put ourselves in that situation, and it animates the case in a demonstrative way from 2 dimensions to 3 dimensions. It becomes something that people experience. Think of the difference between Eric went and saw a great movie and is telling me about it, and I'm like, I don't know. But then I go see the movie for myself and I experience it, and it has a whole different texture.
Yep. And this we talked about deeply, so we're good with this slide. And I think, Noah, it's back to you.
Okay. Yeah, I think the number one lesson that I've learned over the years is if you're gonna use a visual in the courtroom, you have to, going back to the technicalities before you get into the fun and the art of it, like, you have to take every step that you can to lay foundation for your visuals as early as possible in your case. And some people will say, well, I don't know what my visual is going to be at trial before a deposition, so how do I know if the testimony is going to change or whatever? If something changes during the deposition and a witness says, no, actually I was on this side of it, or no, actually the operation that we had, if it's a doctor, was this instead of that. Okay, great. Go back, make a modification to your animation and send it to opposing counsel as quickly as possible, so that they'll never have an opportunity to say, oh, I didn't know that they're sandbagging us. And particularly with medical animations, which we deal with a lot in our cases, TBI cases, spine injury cases, all kinds of like complex biology, biochemistry type stuff. I mean, these animations are gold. And if you're gonna use it at the time of trial, you need to lay foundation for it early. And to Eric's point, it also differentiates your case, and it differentiates you from the other lawyers that are trying to settle a claim or get their client paid on a case. I know that this last bullet point is near and dear to Eric's heart because he used to be a school teacher. If you have a concept, right? Like in biomechanics or crash reconstruction, we talk about a concept called conservation of energy, right? Energy is not created or destroyed, it's only transferred. Well, okay, to lay the foundation for something like that and to kind of break up the monotony of all these paid experts at a trial, hire a local grade school or a local high school teacher like a physics teacher to come in and teach us about conservation of energy, and watch jurors cringe when insurance defense lawyers or corporate defense lawyers try to go after a high school teacher. And these things work both ways, right? There's the the defense bar can call these witnesses too, and they can just be so effective at simplifying things. And so again, when you're thinking outside the box, witnesses can be very good demonstrative exhibits too, and their credibility matters. So we've got all these tools available to us, and the question becomes, okay, in a trial or in your case, how do you pick what you're going to demonstrate? How do you pick what you're going to animate? And really, in whether it be a conservative venue or downtown LA, you've got to be very judicious and careful with the demonstratives that you pick. I think over the course of especially when you're doing scene reenactments, you might get one or two of those in during the course of an entire trial. And so you need to be very, very careful with the ones you pick. So how do you pick? I'm always looking, and Eric kind of taught me this. You look for the tension. Where is especially in a liability story, where is the tension? And the tension is around decision making. The decision of that corporate defendant not to provide its drivers with any change of route information. Well, let's go to the dispatch and see if the dispatch knew about the race that day and chose not to provide their drivers with any further information, or what happened in those moments. If in a damages story, you can see real tension around a decision to have a surgery or not, right? We face it all the time where defense attorneys try to, and it's their jobs and they've got a job to do, and a lot of them do a very good job of this, where they try to amplify the impact, for example, that a lawyer may have had on a decision to have a surgery. It's a very real thing we face all the time. And when you take the jurors into the family room where the family made that decision, and you show the dynamics between all of the people and assessing the risk, the tension around that decision takes on a life of its own, and it really diffuses this type of defense that we see all the time. So that's just a little bit of like how I choose, or how we choose reenactments. And I think the next slide, really what I'm saying, I guess, in so many words with time running out, is make a list of the decisions that had to be made along the way, and pick the ones where there's the most tension. Those are usually good for reenactments because it gives you a scene, like a living room or a tailgate safety meeting, or walking around your truck as which Eric is now has a commercial driver's license and is qualified to drive a semi. So he could tell you all about pre-trip inspections and how important they are.
I sit this afternoon for the driving portion of it. So I don't have it yet, but I've done a 160-hour course on it. So,
So you don't want to. All right, I don't mean to jinx you.
I have driven big rig tractor trailer around San Diego for the past 2 weeks, 15 hours of driving. Anyway.
Yeah.
Anyway, back to you. That's demonstrative.
Well, and I think this is important, right? Like, why did you do that? Why did you go through that training? Why did you wake up at 4 o'clock in the morning every day so you could lawyer for 2 hours and then go be a truck driver, learn how to drive a truck all day? And it's so that when you have a client whose life has been devastated by a big rig crash, you can bring that to life. You can bring those decision points to life. You can understand what the pressures are that a driver faces from behind the wheel. They've got routes, traffic is piling up. They've got a refrigerated truck that they've got to get to Phoenix by the end of the day. You know, you understand that now and can bring that to life for jurors in a way that um, you know, the rest of us with the class, you know, the regular driver's license can't necessarily do. So these are the lengths that you go to understand where the tension is. Keeping it simple and I think the most important part of this is clarity beats cool. You always want to do the legwork to make the demonstratives or the demonstrations as simple as possible while also not losing anything. And you know, Eric mentioned focus groups. This is the kind of stuff where you stack a bunch of visuals up that you've got ideas for, you've got rough drafts of all of them, and you put them in front of focus groups. And focus groups these days, it's probably a CLE for another time, but they're you know, probably some of the it's the best $1,200 you'll spend on any case to figure out how people are reacting to the ideas that you have. And really, you know, I think a lot of lawyers and myself included, I used to go into focus groups thinking I needed to win the focus group. No, I try to go into these focus groups and fail as spectacularly as possible, because then I'll learn. um, I'll learn how folks are reacting to the crazy ideas that are bouncing around in my head. Um, Again here, so there's so much that goes into trying to decide how to demonstrate something versus create an animation versus show a photograph. Um, Things like where there's a decision being made among people, those are ripe for demonstrations. Get people into the well of the court, have people stand up during depositions, orient the scene, and run the dialogue as it's spoken. Um, Timelines are also really good for demonstration. Eric talked about blocking. What is blocking? Blocking it in theater is you pick a specific location and you load that location with meaning, and then you move to another location. So you could imagine a medical timeline where you've got 5 or 6 different key decision points along the way, and every time you talk about the decision to have the neck surgery, you go to that point in the timeline and you talk about it from there. It becomes an interactive timeline, and it really sticks with people. It's a theater technique, but we use it all the time. When you've got medical and technical like medical information or surgeries, you know, those are very difficult to get up and demonstrate. So those kinds of things where you have to go into a location that people can't go, those are typically good for animation. So Eric, do you have anything you want me to move on to the next?
I think we're good to keep going.
Okay, this one's you.
Yeah. So, and we got 2 minutes and 40 seconds left of our 60 minutes. So I'll do this kind of quick, but shout out to Deborah Chang. I saw her present about the use of music in the courtroom. And then with that, Noah, you can go to the next slide too, because I can talk about these in tandem. Music and silence. So music or the lack of music, silence or sound, the lack of sound, voice, the lack of voice, all that stuff can be very powerful. Also, cadence, rhythm, and this is just like the musician side. It's if you vary it, several things. One, it makes it more, it can make it interesting. And also you're giving the listener the ability to absorb what it is that you just said. Now, and the music can supplement that. And actually getting ready for this morning, I was listening to Danny Elfman, his score for Edward Scissorhands. So I encourage you, like, start listening to scores of movies or video games or whatever. Or there's a great podcast called The Soundtrack Show, that talks about like a bunch of John Williams pieces and just a lot of other folks. But like music and how it supplements the story that you're telling can be so powerful as long as it's done the right way. Same thing with silence. You know, so many, we've seen the lawyer that's like just trying to oversell something and then they make a point and then they make the silence. And it's like, all right, buddy, like we get it. You're trying to, but you got to be honest about it. And silence with struggle can be very great too. Like if you're like, you don't always need to be polished. And many times jurors want to see that demonstrative of the struggle of like, you're really trying to find like what that right like word is or phrase to be able to say. And then you're varying your tone, like all that, like we are a demonstrative instrument that we're doing with our voice. And it can be very, very powerful as long as you do it the right way and it's very honest. If you do it the wrong way and it's not honest, people will burn you for that. So we'll go to the next slide.
Yeah, and that too is comes from focus groups. Focus group your case as much as it makes sense to do. And there's so many like inexpensive ways to do focus groups that you just get so much value from. And practice getting up and conveying what you're trying to convey and doing it in a way that is authentic.
Yeah. So I'll just hit this quickly. This is, I think, Ernest Hemingway
Yes.
quote. Okay. So it's this movement, and there's some books on like the 6-word story. So, this may be a good demonstrative or maybe a good trial theory that you're putting together. So, used for sale, baby shoes never worn. Sorry, my timer's going on for 60 minutes. For sale, baby shoes never worn. And that could be a powerful theme, and you can create some powerful demonstratives from that. I think I'll just leave it at that.
Yeah. Again, getting it down to like the short, impactful uh way, like getting your demonstrative, your scene down to the minimum that you need to convey the impact is the big challenge for us, because we have the curse of knowledge as the lawyers. We know the case from every angle, upside down, inside out. But jurors, they don't have the time, and judges don't have the time, and other witnesses and defense lawyers and whoever you're negotiating with or whoever your audience is, they don't have the time. And you got to convey it quick but impactful. And that's really the work of demonstratives.
Yeah. Well, Noah, back over to you. I know that we're over our time, but what are your thoughts?
Yeah, I'll hit these real quick. Eric touched on it. Lawyers are also demonstrative exhibits in the courtroom. And what I try to do is everything that I'm doing is to try to get the information that jurors need to decide the case, or to get a judge what he or she needs to decide, hopefully in my favor, or if not, they'll come down on me too hard, kind of thing. And we do that with body language. So I try to filter everything to the jurors. I never turn my back on jurors. If we're running a crash animation or a demonstration too, I try to run the action in parallel to jurors so that they don't get hit by the car, which can be, off-putting for folks. I mean, there's sometimes where maybe you want that to happen, but when you got people engaged with their mind's eye, and it stuff like that, you've just got to be really careful with. And so I try to usually run the action in parallel to the jurors. Um, Priming is something that there's a ton of information out there on. Malcolm Gladwell writes about it. These books, Persuasion and Persuasion. The idea again is to hand, if you've got an animation, you've got to hand jurors the lens that you want them to look through. And that concept is called priming. So you tell them what they're going to see before you put the video up or the animation up. It's one of those situations where the juror's mind's eye and imagination can really work against you if you're not clear with them what they're supposed to be looking for. So I invite everybody to dig into this. It's a very simple concept that has pretty complex implications for audience. And we've talked about it a lot. Using focus groups. Eric is somebody that really taught me a lot about how to run focus groups effectively in a short period of time. I'm talking about, a 3-hour focus group where you run 4 cases, or 5 cases, and he's got this down to a science. So it's probably a CLE for another day. But there's all kinds of services out there now that help you run focus groups, not just with a group of, 12 people, but you can really test your case with 400 or 500 people. Sean Claggett, the Jury Ball folks, Joseph and Alicia Campbell. These are folks out there that have just have dedicated a lot of their lives to running effective focus groups for especially civil lawyers that are representing people that, we might get into trial once or twice a year if we're trying cases consistently. So, and your client only gets one shot. And so it's very important to know where you can lose your case as much as how to win your case. And focus groups are a big piece of that. I'm kind of flying through this. This is another really good resource. Sash Oliver's a trial lawyer. His book is titled exactly what it is: Depositions or Trial. And he talks about creating the visual culture of your case very early and doing that in your depositions. And he has these crazy ideas about, he'll film a deposition from 3 different angles, right? And he'll set up toy cars and different things to orient people in a crash scene. And then, from the top camera, he'll be able to show it. And then he's got that video and testimony for trial. So this is a fantastic timeline, or a fantastic book about creating a visual culture in your cases and really testing it in depositions. Because those depositions, these days, a lot of those clips, they can be used at trial, and you can really have a lot of powerful exhibits going into a trial. Eric, I'll let you bring it home.
I think, why don't you just bring up the last slide with our contact information? Because
Sure.
I think the last part is really that this is all an art, which we've talked about, and go out there and have fun with this and try to play with it. So, any parting thoughts?
No, I'm feeling a little rushed here at the end, and it just reminds me that they call it practice for a reason. And this journey of law practice is a lifelong pursuit. So go out there. My motto these days when I'm going out there to try something is to try to fail as spectacularly as possible. And I hope we didn't fail today at communicating this stuff, but usually failing spectacularly is more fun than trying to be perfect. So thanks for having us.
Yeah, thanks, Justia.
Awesome. Well, thank you both so much for all of your insights. Just a lot of really great information and resources. So we're so grateful to have had you both. But as Nora and Eric mentioned, if you have questions for them, since we're over time, you can always reach out to them via the contact information. I've also put it in the chat should you need to copy and paste it, or you can always reach us at support.justia.com, and we're happy to facilitate that connection as well. So thank you all so much for joining us for another Justia webinar. As we mentioned earlier, don't forget to take advantage of our powerful and free legal resource available to Justia Connect members, our Justia Daily Opinion Summaries. You'll get next day email alerts when you sign up for these. They will contain concise summaries of the latest court opinions for both the jurisdictions and practice areas of your choosing. You can sign up for free at newsletters.justia.com so you never miss a key legal update. Thank you all so much for joining, and have a wonderful rest of your day. Thank you all so much. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.